Silvana Reed, Assistant Public Defender, with and on behalf of Mr. Brown. Mr. Brown, could you please unmute and state your name for the record?
Aaron Brown.
Thank you. Your Honor, we have reviewed probation's recommendation. It is for jail time, and so obviously this is not something that Mr. Brown is looking forward to, but he does understand that is most certainly what the court will order. We would just like to ask, if possible, for him to be allowed to turn himself in on Friday, as he has a bit of time to serve in custody and would like to be able to get his affairs in order.
Is there anything you want to say?
I got prom next month. I've been here 17 years. I'll turn myself in after that. I'm not coming there Friday. I ain't missed a beat with my daughter. I've been here the whole 17 years. I can't turn myself in Friday. I don't want to go against your orders. I wish it could be another way. I'm not running from you. I had this thing on when I come to you. I turn myself in, but it will not be.
Welcome back to the courtroom. And trust me, you'll want to stay for this one. Today, we got not one, but two defendants testing Judge Simpson's patience. It starts with Mr. Brown, a man facing jail time, but hoping for leniency. His lawyer is doing damage control, trying to negotiate just a few days of freedom so he can get his affairs in order. Sounds reasonable, right? But the calm before the storm never lasts long in Judge Simpson's court. Then we meet Isaac Ellington, a man whose excuses for a failed drug test would make even Hollywood scriptwriters pause. From emotional pleas to bizarre explanations about touching cocaine, this session is pure courtroom chaos.
Tell you what, you can elect to do it your way, or you can elect to do it my way. That's going to be your choice. You decide you don't want to do an alcohol screening and assessment. You don't want to do anything. You continue to violate on the scram tether. So here's what we're going to do. It's a sentence of the court. I'll just order the $125 statutory fees. I will order 93 days in the... Well, hold on a second. Is that the max on this? Yeah. I'll order 93 days. No, hold on a second. What did he plead to? Operating one. Okay. I'll order 93 days, Washtenaw County Jail. Credit to defendant to serve the balance. Defendant has told me he doesn't want to report, so we're going to do it this way.
I didn't tell you.
You report. I'm going to order that you don't get to choose your time.
I mean, can we work?
I'm going to order that you report to the Washtenaw County Jail by 6 p.m. today. Failure to report there'll be a bench warrant issued for your arrest. That bench warrant will issue with no bond. So you don't report 6 p.m. today, your choice. I'll send people to get you. It's real easy for me.
And there it is, the moment everything unravels. Brown had one job: stay quiet and let his attorney handle it. Instead, he took the mic and declared, "I'm not coming Friday," in one breath. He turned a small chance at flexibility into a fast track for a bench warrant. Here's what people often forget. When you're in court, the judge controls the timeline, not you. Brown's words weren't just defiant. They were a challenge. Judge Simpson doesn't entertain challenges. He enforces consequences. When a defendant sets their own surrender date, it screams lack of accountability. And that's a one-way ticket to losing the court's mercy.
Versus Isaac Ellington.
Assistant Public Defender Cosimo Bessi on behalf of Isaac Ellington. Mr. Ellington, could you unmute and state your full name, please?
Isaac Ellington.
Mr. Ellington, did you get a chance to review the PSI that I sent you to your email?
Yes.
Are there any corrections that you want to address?
Yes. A community pressing. I was never doing drugs. I got a friend, high school friend of mine. I've been trying to stop for him doing drugs. Hold on. Stop him for doing drugs and taking drugs from him. And the next couple of days, he passed away. I've been clean. I was dropped yesterday. I've been negative. I've been clean. I just lost a good friend of mine of the drugs, and he never woke up. And that's why I got the positive because I've been taking.
So you're saying you didn't do drugs?
No, I didn't do drugs. I didn't do drugs, and I got one positive in April, and I'm like, and another one. I've been.
So you're saying positive for cocaine's, aren't you?
No, that's not. It's me because I'm taking it from my friend. He passed away now a couple days ago.
You took it from your friend, and then how did it get into your system?
It probably because
Notice how the tone shifts instantly? Judge Simpson goes from calm to commanding, laying down the 6 p.m. deadline. No confusion, no wiggle room. That's what courtroom authority looks like in real time. Many defendants think they can negotiate their punishment. They can't. The second Brown says, "I can't turn myself in Friday." Simpson responds with a masterclass in judicial control. And the lesson? When a judge offers you a choice between compliance and defiance, there's really only one smart option. Brown's "not coming Friday" line, that might just be the quote that cost him his freedom.
taking it from.
Oh, so you touched the cocaine and then you tested positive.
Yes. Then
Oh.
I was negative.
Okay, is that the story? Is that really the story you're going to go with?
Yes.
You want to talk to your attorney before you stick with that story?
Yes, for real. I've been honest.
No, but do you want to talk to your attorney before
Mr.
that's the story
Ellington?
you're giving me? Because this recommendation will change.
Mr. Ellington, I would advise you to accept what the recommendation is saying and ask the court to adopt that recommendation.
How about this cocaine, though? Because he's telling me that he didn't do it.
I would just ask the court to disregard Mr. Ellington's previous statement.
Well, I
Mr.
can't disregard it. That's like unringing a bell. I heard him.
Judge Simpson, I'm honest. I've been coming to court. I've been doing everything.
I know you're honest, but not an amoeba. You don't absorb things that way. So, counsel, you don't normally do this, but you want me to give you a breakout room to talk with him?
Yes, please.
And then we can talk about how the cocaine got there?
Oh my God.
Yes, please.
Yeah, I know.
Okay.
Now, just when you think the courtroom's cooled down, in walks Isaac Ellington, and things take a bizarre turn. His story? He didn't use cocaine, he just touched it. That's right. According to Isaac, cocaine somehow seeped into his system through skin contact. Even the judge looked stunned. This kind of excuse might work in a bad movie, but not in front of a seasoned judge. What's happening here is more than denial. It's a credibility meltdown. Every word Isaac says digs him deeper. If you've ever wondered what not to say in court, this is Exhibit A.
Sir,
Mr. Ellington.
sir, I don't doubt that part. I doubt the other part you just told me. Because, and I'm just going to lay it out there, you had a positive for methamphetamines on March 23rd. March 28th, you're positive. Hold on. You're positive for cocaine. You go away. You do have a negative test in between then. Come back April 3rd. You're positive for cocaine again. So, and he didn't go to the CCOP program. So this may change in any event. Sir, I'm just going to ask you, do you want to go into a breakout room and discuss this with your attorney prior to the court proceeding forth with sentencing? Because I'm ready to go.
Judge Simpson gives Isaac a small window, the breakout room. That's basically the legal version of a timeout, a moment for the defendant and lawyer to regroup before disaster strikes. But let's be real. Once a judge starts doubting your honesty, that doubt lingers. The test results don't lie. Positives for both cocaine and meth within weeks. So, when Simpson says, "Do you want to discuss this with your attorney?" it's not kindness, it's strategy. He's giving Isaac one last shot to align his story with the facts. Because when your defense becomes more fiction than fact, you're only negotiating the size of your sentence, not your innocence.
The amazing Mr. Ellington into a breakout room, and then we can bring them back momentarily. Court recalls the case. People versus Isaac Ellington.
Yes, Assistant Public Defender Costa Mubesi on behalf of Isaac Ellington. Mr. Ellington, could you unmute, please? State your name again.
Isaac Ellington.
Once again, Your Honor, we have reviewed the PSI, and Mr. Ellington does not have any. He would like the court to adopt the recommendation. Mr. Ellington, would you like to go ahead?
Yes.
Okay, so what about the cocaine? I'll wait.
I was helping my friend out. I did it once or twice, Your Honor.
You did what?
I did it once or twice, Your Honor.
Finally, Isaac admits it. He did use cocaine once or twice. It's a small confession, but it lands like a weight in the room. Judge Simpson's tone softens slightly, not because he's impressed, but because he values honesty, even when it's late. This is a difference between total defiance and reluctant truth. The court isn't forgiving, but it's fair. Isaac gets probation, random testing, and a warning sharper than any sentence. Lie again and it's straight to jail. In Judge Simpson's world, truth doesn't erase mistakes, but it might just keep you out of the cell barely.
So you actually ingested the cocaine?
Yes, Your Honor.
Yeah. That's a much better story than the first one you gave me. Sentence of the court, 12 months probation, $655 fines and court costs, $360 probation oversight fees. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You know what? No, he's going to continue on his testing.
Oh.
Yeah.
Honor, I will be clean. I swear, Honor.
Well, here's what we're going to do.
No more.
You know, I hear you. So I'm going to give you a chance to prove yourself to me.
Okay.
Ms. Valera, I want him on testing, random testing through community corrections for the next 60 days. You're to complete the CCOP program or a comparable program. Now, when you do that testing, I'm just going to let you know. Any positives, you might as well just prepare for jail time. That's how I'm going to work this. I don't like people not telling me the truth, and you tried to start out not telling me the truth.
Okay, Your Honor.
You're to maintain employment with proof to probation. I'll order 365 days in jail. Credit 2. Defendant will serve an additional 5 days for the bond violations to date, and then the balance will be suspended. You are ordered to report to the Washington County Jail by 6 p.m. So I got 360 other reasons why you don't want to use. We clear?
Yes.
Thank you. Report to the jail by 6 p.m. or bench warrant will issue with no bond.
Your Honor. Okay.
What? What do you want to tell me?
I was gonna tell you, can I do it Friday? I could tell my job to hold my job.
And just when you think the tension's done, Isaac repeats Brown's mistake. He asks if he can report Friday instead of today. You can almost hear the collective courtroom sigh. After all the warnings, all the second chances, this request feels tone deaf. To Isaac, it's a simple favor to keep his job. To Judge Simpson, it's deja vu. Another defendant testing his authority. And that's the irony here. Both Brown and Ellington fell into the same trap, believing the courtroom runs on personal convenience. Spoiler, it doesn't. When a judge says 6 p.m., he means 6 p.m., not when it works for
you. Know what, Mr. Ellington? I would have been more than happy to do that. But the problem is you came to me lying to me. I don't know right now whether or not, hold on. I don't know whether or not you're telling me the truth right now.
I am telling the truth because I'm at my
So
job.
the problem, hold on. The problem, Mr. Ellington, is when you start out like that, I can't trust you. I can't trust you that you'll be there Friday. I can't even trust that you're going to be there tonight. But I can tell you, if you're not there tonight, what's going to end up happening? I'm going to send somebody out to get you. Thank you.
Your Honor, I would just like to say that Mr. Ellington has expressed to me how concerned he is about keeping his job. And since him keeping his job is part of PSI's recommendation, I mean, if we could just get a day possibly or two and then have him report maybe by 6 p.m. tomorrow before the warrant goes out. Just to give him a small cushion to get his job straightened out.
No, not doing it. I told you what I'm doing.
Thank you, Your Honor.
He did what he did. Now I'm going to do what I'm going to do. That's just the way it works with me.
I will be there. I'm sorry.
And counsel, you know, if somebody had come to me and said, yeah, I accidentally used, or I shouldn't have used, I did this, then I'll deal with that. But if you come to me just straight up lying and I'm telling you, I don't believe your story, and you continue to lie, and then I got to put you into a breakout room with your attorney, and now you're going to come back and tell me the truth? Really?
I'm not.
And now you want me to do something for you?
I'm not
don't
lying.
think so.
Honor,
I'm done.
I'm not lying.
I'm done.
So what did we just witness? Two very different defendants, one unshakable judge, and a powerful reminder that courtroom leniency has limits. Brown learned that defiance earns no favors, and Ellington learned that honesty, though delayed, might just save you from the worst. Judge Simpson's courtroom isn't about punishment. It's about accountability. Every word, every excuse, every delay carries weight. And that's what makes these cases so compelling. Real people, real stakes, and real consequences. If you found this case as shocking as we did, hit that like button, drop your thoughts and comments, and subscribe for more jaw-dropping courtroom breakdowns.